Mic check, mic check. Mic check, mic check.
Good morning. On behalf of the Edward M. Kennedy Institute for the United States Senate, I welcome all of you to the Kennedy Caucus Room for this timely and important discussion of the Senate's role, its advice and consent role in connection with the President's lifetime appointment of individuals to the Supreme Court of the United States. The mission of the Kennedy Institute is to educate the public about the important role of the Senate in our government, to encourage participatory democracy, to invigorate civil discourse, and to inspire the next generation of citizens and leaders to engage in the civic life of their communities and of our country. To that end, in addition to our hands-on Senate experience in Boston, we host a series of public programs that highlight the role of the Senate and that focus on the issues of the day. Well, I think you'll agree that the Senate's advice and consent role in confirming nominees to the Supreme Court certainly qualifies as an important issue of the day. We know, however, that the public doesn't fully understand the Senate's important advice and consent role. Indeed, in polling just completed by the Kennedy Institute, we found that only 36% of Americans understand the role that the Senate plays in confirming Supreme Court nominees. That's really something, and we have our work cut out for us. But I feel that after today's discussion, we'll have a much clearer understanding, all Americans will, about that important role. So it is my great pleasure to introduce our speakers and our panelists here today. We have my very dear friends. First, President Pro Tem of the Senate, former Chairman of the Senate Judiciary Committee, Orrin Hatch, Republican from Utah. The ranking member of the Senate Judiciary Committee, former President Pro Tem of the Senate, Patrick Leahy, Democrat from Vermont. They will be both making remarks in just a few minutes. We're also pleased to be joined for important panel discussions by Marty, partner with Capitol Counsel LLC, and Jeff Blattner, President of Legal Policy Solutions, PLLC. Marty worked in many senior positions in the Senate, culminating in his role as counsel to Senate Majority Leader Howard Baker. Jeff served on Senator Kennedy's Senate Judiciary Committee staff for many years, and he became his chief counsel in 1992. During his time with Senator Kennedy, Jeff was the lead staffer on 6 Supreme Court nominations. If anyone understands the role the Senate plays in the Supreme Court justice nomination process, it's all of the gentlemen we'll be hearing from here today. The moderator of our panel today is Chris Geidner of Buzzfeed, and without further ado, I'll turn the program over to Chris. Thank you all for being here. We're all looking forward to learning a lot today.
Thank you all for being here this morning. I believe we're going to start with some comments from our esteemed senators who have joined us today, beginning with Senator Hatch. So I call you up first.
Well, I'm certainly delighted to be here today, and Vicki Kennedy's one of my favorite people in this world. I remember what a difference she made in the life of my really dear friend, Ted Kennedy. Ted was, we did a lot together. We fought each other regularly. We got in some awful battles, but we also agreed on a lot of things too. And when we agreed, it kind of said to everybody, they better stay out of the way, and we'd be able to get some things done, and we did get a lot done. I'll never forget, he'd be yelling and screaming on his side of the floor as only Ted Kennedy could do with that booming voice of his. And I'm standing over there ready to punch him in the mouth, because he was getting on my nerves. And when it was all over, when the debate was over, he'd come over and say, "How'd I do?" How did you get mad at somebody like that? Well, I'm glad to be with you for a few minutes today. I served with Senator Kennedy on the Judiciary Committee for 32 years. In fact, he's the only senator who has served on the committee longer than I have. I know this makes me sound older than I am, but half of all life-tenured federal judges have been appointed since I joined the Judiciary Committee. The judiciary appointment process is an example of how America's founders sought to limit government power by dividing it. The president has the power to nominate, but cannot appoint without the advice and consent of the Senate. And debate continues about how robust or assertive the Senate's role should be. Three significant events, occurred in the Judiciary Committee on January 1979. Senator Kennedy became chairman. Senator Leahy joined the committee, and the first hearing of the 96th Congress focused on the selection and confirmation of federal judges. This ongoing issue is obviously front and center today following the death of Supreme Court Justice Antonin Scalia. The Kennedy Institute's poll earlier this year found that only 36% of Americans know that the Senate has a role, or has the role, of advice and consent in the appointment of Supreme Court justices. Raising that awareness, however, will do little good if Americans are aware of, but misunderstand, the Senate role. Using the Scalia vacancy as an example, I want to make three brief points. First, the Constitution gives the Senate the power of advice and consent, but does not specify how the Senate ought to exercise that power. Claims that the Constitution dictates when and how the confirmation process must occur, such as the immediate committee hearings, immediate committee hearings and timely floor votes are false. In fact, the Judiciary Committee was not created until 29 years after the Constitution was drafted. Second, the Senate has conducted the confirmation process in different ways at different times under different circumstances. The Judiciary Committee held its first public hearing on a Supreme Court nomination in 1916, but the nominee did not appear. The regular practice of nominees appearing publicly before the committee did not begin until the 1950s. Earl Warren, for example, did not appear at his 1954 confirmation hearing to be Chief Justice of the United States. In a 2014 report, the Congressional Research Service said this, quote, "Neither the Judiciary Committee nor the full Senate is compelled to act on nominations which come before it," unquote. Our former distinguished colleague Robert Byrd made the same point in a 2006 speech when he said, quote, "There is no stipulation in the Constitution as to how the Senate is to express its advice or give its consent. The Senate can refuse to confirm a nominee simply by saying nothing and doing nothing," unquote. Now that is why the Senate has a standing rule providing that nominations that are neither approved nor rejected are returned to the President at the end of the two-year Congress. Nearly 1/4 of all Supreme Court nominations were never confirmed, nearly 1/4. Another CRS report identified nearly a dozen different scenarios for how these nominations were handled. Some were referred to the Judiciary Committee, but never reported to the full Senate. Some came before the full Senate, but were never considered at all. As a simple matter of historical precedent, the Senate has never confirmed a Supreme Court nominee to a vacancy occurring this late in a president's tenure. The Constitution does not mandate a one-size-fits-all confirmation process, but leaves these judgment calls for the Senate to make. We tend to focus on the Supreme Court, but the same issues apply to the confirmation process for lower court judges as well. As Pat and I both know by experience, for example, Judiciary Committee chairmen of both parties have often decided for different reasons not to conduct a committee hearing for various nominees. The committee likewise has not always voted on each nominee who has had a hearing. To suggest otherwise is to misstate historical fact and misrepresent the meaning of advice and consent. Now, my third point is that the Senate majority has made its judgment call regarding the Scalia vacancy. For two reasons, we have decided that the confirmation process should take place after the presidential election season is over. First, conducting a heated, divisive confirmation fight in the middle of an ugly presidential election, and that certainly describes ours, our presidential election, or should I say season, that is well underway, would do more harm than good. Harm in the confirmation process to the nominee and to the country. The second reason to defer the confirmation process is that elections have consequences. The 2012 election had consequences for the president and his power to nominate. The 2014 election had consequences for the Senate and its power of advice and consent. And the 2016 election will have consequences for the American people because they can have a voice in the direction of the courts. The issue is when and how, not whether, the Senate should consider a nominee for the Scalia vacancy. I don't want to throw off the schedule for this event right out of the gate, so I will leave it at that. The Senate plays an important role as a check on the president's power of appointment. As senators of both parties have noted over the years, the Senate does not play a rubber stamp. Opinions differ about how deferential or forceful the Senate should be, but the Constitution leaves that judgment to us. James Madison wrote that a well-instructed people can be a permanently free people. That is the Kennedy Institute's mission. It's a great institute. I've been happy to support it. I'm happy to support Vicki in any way I possibly can. And all I can say, the Kennedy Institute's mission is a great mission. And I want to thank you all for all that you do. Thank you so much. Appreciate being with you this morning.
And now to voice his complete agreement with everything that was just said, I believe we have Senator Leahy.
Thank you very much. And, you know, being here, Vicki, it's always great to be here with you. And on here in the Kennedy Caucus Room, and just around the corner from where Ted's office was. And I loved, because my office is just above here, we used to end up going over to votes together all the time. And I so often recall we'd start off and he'd say, "Pat, did you hear the one as we're walking through the halls?" And then we'd start, and then you had that booming laugh. And of course, with the marble halls, it would echo through it. Everybody would look around and they'd say, "What was the joke?" And we'd say, "We forgot." But we had a wonderful time. I also learned so very much about him. You know, the Kennedy name is synonymous with public service. Ted, of course, dedicated his life to the people of Massachusetts, but just as importantly, the people of America, especially the disempowered, the disadvantaged. That's an inspiration to all of us. And I wish today we had more of the Senator Kennedy's commitment to the Constitution. And I hope that this event might remind us what it means to be a true public servant in the Kennedy mode. It means having the government work for the people. It means understanding how our lives affect the people we serve. It means appreciating the awesome responsibilities of a U.S. Senator. There are, after all, only 100 of us to represent over 300 million Americans. It means rolling up our sleeves and setting aside partisan bickering, finding ways to get done. And with today's event, I'll give you the most recent example. Of course, we've had numerous Supreme Court nominees confirmed in election year. Every time there's been a vacancy in the Supreme Court in an election year, we've confirmed them. There aren't that many vacancies that occur in election year, but every time it's happened, we've confirmed the nominee. The most recent, and my good friend from Utah may have forgotten this, but the most recent event was when Ronald Reagan was president. the Democrats were in control of the Senate and were unanimously confirmed in a presidential election year President Reagan's nominee to the Supreme Court. It would be kind of nice to follow the most recent precedent. Now, I know, serving on the Judiciary Committee, some of the most pressing issues are there. And Ted Kennedy made those front and center to the American people. Immigration, civil rights, two of the most important ones, but also the nomination of Supreme Court justices. And let me just quote Senator Kennedy, because I totally agree with him. He said, "Few responsibilities we have as senators are more important than our responsibility to advise and consent to the nominations by the President to the Supreme Court." Nobody disagreed with him at that time. Some of those who were serving with him at that time now take a different view. Ted understood the momentous nature of Supreme Court nominations. He understood the historic and constitutionally mandated role of the Senate. So it is important that today's event focuses on the Senate's undeniable and irreplaceable role in providing advice and consent to the President's nominees. Now, Senator Hatch and I disagree on this because we know this is exactly what the Judiciary Committee should be doing this very week. If we followed the normal course, once the President makes the nomination, members of the Senate Judiciary Committee review the nominees' records, we hold public hearings, we've done this, and then we vote on the nomination after careful deliberation. If we followed normal routine, we would be holding those hearings this week. This is how it's been for the last 100 years. In fact, when I became chairman of the Senate Judiciary Committee in 2001, during President Bush's administration, I and the then ranking member of the committee, Senator Hatch, memorialized how the committee would continue in this tradition to consider George Bush's Supreme Court nominees. He and I sent a letter to all senators, and we wrote, "The Judiciary Committee's traditional practice has been to report Supreme Court nominees to the Senate once the committee has completed its considerations. This has been true even in cases where Supreme Court nominees were opposed by a majority of the Judiciary Committee." Senator Hatch and I agreed on it. We gave our word to the U.S. Senate. That's the way we would do things. And the Republican leader, Trent Lott, agreed. He took our letter, he put it in the record, and he said, "The Senate has a long record allowing the Supreme Court nominee to be given a vote on the floor of the Senate." Close quote. All of us, Republicans and Democrats, agreed to this because that's what we in the Senate have done for a century. Democrats agreed to that, even with a Republican president. Republicans agreed to that with us. I want us to keep our word. I want us to keep our word and do it in an open and transparent manner. Now, the Kennedy Institute, as Vicki indicated, released a national poll that only 36% of the American people know the Senate confirms Supreme Court nominees. Now, our reaction to this should not be to deny Judge Merrick Garland a public hearing and a vote which would break 100 years of tradition and mean that we were failing to do our job. Instead, our response should be to engage with the American people, show them through our actions, have a public hearing. You know, a solid majority of the American people does know by a 2-to-1 margin that Chief Judge Garland deserves to have a hearing. And we should do our job, follow our constitutional duty. Some claim that their unprecedented obstruction against Chief Judge Garland is based on principle, not the person. Well, balderdash. That's not true. Some dared President Obama to nominate Chief Judge Garland. They praised his bipartisan support. and his consensus building style. Some of the same people who object to a hearing for him now say this would have been a good person for President Obama to have on the Supreme Court. Others have attacked Chief Judge Garland's record. They've used some of the dark money groups to attack it. Well, then at least allow him a public hearing where he can respond. You know, it's not a principled thing to attack him knowing they can't respond. And by not voting, what they're doing is voting maybe. They can take any position they want. They can say, oh, yeah, I met with him, and of course I met with him, and knowing they'll never have to vote with him if they can keep blocking it. They never have to be on either side. Well, we're elected to vote yes or no, not maybe. You're going to hear a lot about some of the Senate's most memorable confirmation debates. You see the Senate has considered controversial nominees. But in every one of those instances, the nominee received a public hearing and a vote. What would be historic is to deny Chief Judge Garland a public hearing and a vote. That would be historic. Well, this senator does not want that to be part of the history of the United States Senate. You should demand your senators do their job by providing this nominee a public hearing so he can respond to the attacks on his record. I believe that's what Ted Kennedy would be doing. You know, it's easy in politics to appeal to self-interest, but Senator Kennedy appealed to the best of us. He appealed to our sense of justice, to our sense of responsibility, to our uniquely American belief in hope and possibility. He appreciated the role of the Senate. You know, sometimes you have to be an instigator, sometimes a defender, sometimes a compromiser, but we are called to fulfill our constitutional duties. We are called to lead. We need to do our job. And it's my sincere hope that we'll follow Ted's example, uphold the finest traditions of the Senate. And now what I would like to do, if Vicki, if you could come up here, I just have a personal thing I'd like to do. This is something I inherited when I became chairman of the committee. It is Ted Kennedy's gavel that he had when he was chairman. Let me hold it up. The gavel, and it says, Senator Edward Kennedy, U.S. Senate Committee on the Judiciary, 1963 to 2009, Chairman, 1979 to 1981. And I saw him wield that gavel.
This is so beautiful. It's unbelievably beautiful and so meaningful. Ted Kennedy loved the United States Senate. He said the greatest honor of his life was to serve the people of Massachusetts in the United States Senate. And the Judiciary Committee, along with what became known as the Help Committee, were his two first committees. This meant so much to him. He fought for what he called the March for Progress. That's what the Judiciary Committee meant for him, constantly fighting to make America America, fighting to move us forward, fighting for that March for Progress. He believed that's what the Judiciary Committee did. He was proud to serve on it. He was proud to, for his entire time in the United States Senate. As it says here, from 1963 to 2009, we will cherish this always. It will have a place of honor at the Kennedy Institute and in my heart, as do you, Pat. Thank you.
Thank you.
Thank you. Thank you so much.
Thank you so much to Senators Hatch and Leahy for those opening remarks that clearly frame the two sides of the issue as we find ourselves in today. And thank you very much to Mrs. Kennedy for your time. She informed us that she actually has a noon meeting up in Boston and still found her way to be down here this morning. So we obviously greatly appreciate that. We have a few minutes here to talk with two experts at this issue over the history of the past 30 years, really. And I wanted to start a bit with Marty Gold, the former counsel to Majority Leader Howard Baker, and the well-known author of the Senate Procedures and Practice book, to talk a little bit about the history here. What is this advice and consent that we talk about in terms of how it actually exists and what is required of it?
Thank you very much. And I want to say thank you to the Kennedy Institute for hosting this program. I had the opportunity to come to work at the United States Senate 44 years ago. Senator Kennedy was serving then, and I had an opportunity to watch the career of one of America's great senators, not only in the era in which he served, but in all of the American history. So it's a great honor to be here and to be with all of you. The Constitutional Convention met between May 29th, 1787 and September 17th of that year. There have been a number of wonderful books written about that Constitutional Convention, two of them, The Summer of 1787 by David Stewart and Plain Honest Men by Richard Beeman. And they talk a lot about the issues that divided the members of the Constitutional Convention, the framers of the Constitution. But those issues principally did not involve this power, but really, for example, the construction of the United States Senate itself, a proportional body or a body with equal representation for all the states. So to find studies that actually dissect this power, one can look to an article that was written by Adam J. White in the Harvard Journal of Law and Public Policy in 2005. Mr. White was testing a proposition from President George W. Bush, who, in the aftermath of his 2004 re-election, said, "The Senate has a constitutional obligation to vote up or down on president's judicial nominees." This was December 23rd, 2004. Mr. White decided to test that proposition and came to the opposite conclusion, that the Senate did not have a constitutional obligation, only a power. But how does that happen? If you trace this through the Constitutional Convention, there is one basic principle of politics that is observed there, and that is, nothing is settled until everything is settled. That is to say, when they drafted the Constitutional Convention, beginning first with the Article I powers of the legislative branch and then turning to the Article II powers of the executive branch and then to the Article III powers, they obviously understood that as they made changes as they went along, it would affect things they had previously written. So from the beginning of the convention, George Washington, who presided over it, said they would have a right of reconsideration, that anything that had been voted before could be revoted again, because as you made adjustments going down the line, you might have to rethink what you had done previously. And this is what happened to this advice and consent power. The role of appointing judges was first advanced in the Virginia plan to this Constitutional Convention set up by Edmund Randolph. In that case, you had a House of Representatives chosen not as the Articles of Confederation Congress was, with one person per state, but on the basis of population apportionment. He's representing the most populous state in the country, Virginia, and he's saying the House is going to elect the Senate, and together they will appoint the executive, and together they will appoint the judges. Others sought to disagree with this. So when it finally came before the Constitutional Convention in June the 5th of that year, it was criticized by people who wanted more executive power, principally James Wilson of Pennsylvania. Madison of Virginia proposed a compromise. Take the House of Representatives out of it and have the Senate appoint the judges by itself. But it's important to understand that when Madison proposed that, he wasn't talking about the Senate as we know it now. He was talking about a Senate that was going to be based on population, just like the House of Representatives, a smaller body, but also based on popular vote, or at least based on proportionality. Well, this went through. The Senate was chosen by the Constitutional Convention framers as the body that was going to appoint the judges. They agreed to this on June the 13th. Finally, after some other plans were presented, the New Jersey plan, a plan by Alexander Hamilton, the idea of Senate appointment was finally affirmed by the full Constitutional Convention. And then we get into the middle of July when the composition of the Senate is determined. And it's determined not to be as the Virginians wanted it, on the basis of population, but as the people from the small states like New Jersey and Connecticut wanted it, on the basis of equal representation. That becomes a very different matter. That Senate appointing judges is different from a Senate that is related to the population of the entire country. So it causes this question to be reopened. The following day, Nathaniel Gorham of Massachusetts proposed a plan that was akin to what was used in Massachusetts, which was that the upper chamber of the legislature would affirm or not affirm the nominees proposed by the governor. So this notion of the executive nominates, subject to the approval of the upper chamber of the legislature, was put before the Constitutional Convention for the first time. Madison had a different idea. He said, well, look, what if we say the president, the chief executive, can make the appointment, and it will go through unless within a specified amount of time 1/3 of the senators disapprove it. Madison's plan was rejected. The Senate appointment was still affirmed. They hadn't accepted this executive appointment yet, and the Constitutional Convention went on through a committee of detail and other processes through August of 1787. Finally, after the executive branch was set up in August of 1787, a committee on compromise was appointed. The committee on compromise at the end of August, the beginning of September, reports an idea. The president will make the appointments like in Massachusetts, and the upper chamber of the legislature will either affirm them or not affirm them. It was sent to the Committee of Style on September 12th and becomes part of the Constitution of the United States upon adoption on September 17th.
Now, not to cut that off, but in order to find a way to get forward to 2016, we're going to have to to fast forward a bit. And once we had that system in place, can you, Jeff, talk a little bit about sort of where this went into the path where we see ourselves today? And I believe you said that this sort of coincides with your entry into the Senate.
Well, okay. Thanks, Chris. I want to add my thanks to Marty's, to the Institute. Can you hear? For inviting me and for the work they do to study and support this great institution. And I want to thank Vicki for her kind remarks, and most importantly for the joy she brought to the senator. Working for him was a great privilege for me and great fun, and all of us who love him and miss him are so grateful to Vicki for everything she brought to his life. So when we were talking amongst us about how we would, the topics we'd address on the panel, Chris suggested I address how did we get here? And that Billy Joel song, "We Didn't Start the Fire," came to mind. The first Supreme Court nomination that I worked on was the Bork nomination. You might have heard a little about it. It's the only thing I've worked on that's resulted in a verb. But I would submit, and I'll explain, I hope, why I think that's a bit of a bum rap. Over our history, since the founding, about 1 out of every 4 to 5 Supreme Court nominees has not been confirmed by the Senate. Judicial philosophy has been considered by senators since the founding. Indeed, George Washington's nominee to be Chief Justice, Rutledge, was rejected in part because of his views about the Jay Treaty. So I don't remember that. I don't, none of us do. Okay. So why has the situation come to where it has? I would submit that there are two great trends, really, that collided in the 1980s. One is the Supreme Court's role in America really began to change in the 1950s with Brown versus Board of Education, with the Civil War amendments, 13th, 14th, 15th amendments, had not really been taken by the courts as an engine for equality until the Warren Court. So the Warren Court upset the status quo in the country, and the salience of the Supreme Court as an institution grew exponentially over the intervening 30 years, right? There are some here, and I'm among them, old enough to remember impeach Earl Warren signs, impeach William O. Douglas signs in parts of the country. And so the court was becoming increasingly salient. The second thing that happened, and this is something people don't really admit on either, well, particularly on one side of the battle, which is that jurisprudence now understand, lawyers and law professors and judges now understand, and Richard Posner, who, a great judge appointed by Ronald Reagan, perhaps the most candid about this, that being a judge or a justice and interpreting the Constitution is not, as my former law partner said, a matter of being an umpire and calling balls and strikes. That's Chief Justice Roberts. It is instead a matter in which philosophy, experience, point of view matters. And so those two things collided in the 1980s. In the Bork nomination, and in this room for 3 weeks, during which I gained about 20 pounds, the Senate Judiciary Committee considered his nomination. Judge Bork's views were controversial. We could get into that if we had the time. But philosophy matters. Philosophy clearly, how one interprets the Constitution, whether one's views are consistent with that great arc of justice to which Senator Kennedy was dedicated, of course, that Dr. Martin Luther King articulated. That matters. And so the Senate has taken it into account. I don't know how much time we have, but perhaps we ought to talk at some point about where all this goes.
Well, I think the two questions I'd like to get into before as we go through this is this issue of duty. There's been a lot of debate. There was a lot of comments in the comments from Senator Hatch and implied in the comments from Senator Leahy about whether or not there is a duty of the Senate to consider a nominee. And I don't know if you wanted to talk a little bit about that, Marty.
The Senate has a duty to consider a nominee, except how it considers it and how it exercises that duty is a matter of dispute here. I mean, in a sense, inaction is also action. There have been any number of nominees, certainly at the appellate level, and you can go back president after president after president, where the nominees were left on the cutting room floor at the end of an administration because the Senate did not exercise the right of advice and consent by approving the nominees. Sometimes the nominees are bottled up in committee. During 2003, 2004, and into 2005, there were 10 Bush judicial appointments that came out of committee that were filibustered on the floor. There was a filibuster on the Alito nomination that President Obama, Vice President Biden, Senator Hillary Clinton, Senator Reid, Senator Schumer all supported that filibuster. So in that respect, what they were saying was this nomination should not get to a vote on confirmation. In other words, if the filibuster had succeeded as the filibusters had on the Bush appellate appointments in 2003, 2004, that itself would have been a disposition of the nomination. When Priscilla Owen was resubmitted to the Senate by President Bush in 2005, Senator Reid said he shouldn't have done that. The President shouldn't have done that because the successful filibuster of the nomination in the previous Congress was a disposition of that nomination. So at the end of the day, there are many ways that the Senate can exercise that power of advice and consent. Certainly voting a nominee up or down is one of them, but as has been amply established throughout history, there are other ways of exercising it. You get to a situation here, this is not the Madison situation where the President nomination goes through unless the Senate disapproves it. This is a completion power. This is like taking the example of a treaty, for example. The President proposes a treaty, but the treaty cannot be ratified by the President unless the Senate consents. And the Senate can just leave the situation sitting there for years, as it has with a number of treaties. So it's the same exact kind of situation here. This power has been interpreted to be a power of completion, not a power of veto.
It looks like you might have something to say there, Jeff.
Marty and I agree about a lot on this question, but not everything. Of course, the Senate has a duty, and I agree with Marty that it's a question, as many things are in life, of degree. Okay, most situations in life, fine factual distinctions can matter. But here the duty is clear. It really arises from three things: the words advice and consent. Second, the very structure of the Constitution. Each of the branches has a duty that may be implied from the document, something like the covenant of further assurances. They need to, everyone who works in the Senate, and every senator, every president, every justice takes an oath to uphold the Constitution. Part of that is implicit in that is a duty to make the branches work. If the president said, I'm going to veto the legislative appropriations bill — we actually used to have legislative appropriations bills. If the president said, I'm going to veto the legislative appropriations bill, and we're going to let the voters decide in November whether we want to pay these legislators, you're effectively stopping an institution from working. If the Senate, in a fit of pique, said, the justices are coming to us, they want security for the institution, and we're going to decline that in an appropriations bill because we're mad at them, you're breaching a duty that's implicit in the document to make the other branches function as intended. Finally, and there's a certain irony here, many members of a certain party are very upset with President Obama for taking executive action on some subjects and not changing the statutory law. Well, there is a statute on the books that says there shall be 9 members of the Supreme Court. If you want to change it to 8, pass a law. Okay, pass a law. But that's not what I think anyone wants to do. Everyone recognizes there's a duty. The question is, I think everyone agrees, one of timing and one of degree, but you have to have a reason. Elected officials are accountable. This is not a justiciable duty. It is a duty to the taxpayers and to the voters. And ultimately, they're going to decide whether the reasons being offered for not proceeding with a hearing on this nominee are good and sufficient.
So you're saying that everybody agrees it's a matter of letting the people decide. It's a question of whether it's the people deciding if the Senate is doing its job, or as the Republicans would argue, a matter of the people deciding what direction the court should go.
That's right. I sat next to Senator Kennedy in February of 1988 on the floor when he managed Justice Kennedy's nomination. Chairman Biden had an aneurysm and was very, very ill at that time. That vote went through 97-0. Oh. It did not occur to us, well, it's an election year. Michael Dukakis could win. haha, and we don't have to go forward. It's simply.
I mean, obviously there are differences about that nomination. It was the second nomination for the position. The vacancy,
Sort of.
third. Yeah, well, I guess. It also was obviously a vacancy long before the final year, but. A note made when the Senate Judiciary Committee did meet and discuss the nominations, and this is sort of the final point. Obviously, there are lots of discussions about Chief Judge Garland, and I encourage everybody to participate in those discussions. But looking beyond that, a point made by Senator Graham when the Judiciary Committee met was that the eventual endpoint of this is getting rid of the filibuster for Supreme Court nominees. The next time you have a non-filibuster proof majority of the same party as the president. What do you two have to say about that?
You want me to go first, or do you want to go?
I can go first.
Go ahead.
All right. Look, the controversy that associates itself with filibustering judges is a deeply divisive matter here in the Senate, deeply divisive matter. In the first filibuster of a judicial appointment was Abe Fortas in 1968. That was a bipartisan filibuster. But at the time that was done, I can read the words of Senator Mansfield, who was the majority leader, Phil Hart, who was managing the nomination on the floor, talking about the terrible precedent it was going to set if nominations were resolved on that basis. This was a motion to proceed to Fortas' nomination, and it went down 45-43. They couldn't get 67 votes for cloture anywhere close. And then in the early 21st century, that precedent was repeated again and again on appellate court level. It led to substantial aggravation. It led to the possibility in 2005 of the nuclear option. It led to the Senate going to the brink and then having the Gang of 14 agreement, which I heartily, personally endorse and say, thank God they did it, because it brought the Senate away from the brink. And then finally, the brink was crossed in 2013. I cannot say, because he has not told me, why Senator Reid excluded the Supreme Court from that, although some might conjecture that it was because you only get the votes for the nuclear option if you do exclude the Supreme Court from that. But you may know better.
Well, so I actually have an unorthodox view about this, which is, if you think about it, Justice Scalia was asked, what provision of the Constitution did he like the least? And he said, it's too hard to amend the Constitution. Why? It takes 2/3 of both houses, 3/4 of the state legislatures. Why do I bring this up? A justice can change fundamentally the interpretation of the Constitution. And the degree of consensus required, 51 votes, is really not consistent with the constitutional framework. It would be better for the court as an institution if two things were true. One is the parties could agree on nominees, as they often do. And second, that they agree on a going forward basis that, to quote another song, you can't always get what you want. Right. The president gets to decide, but you have to take account of the balance of power. As Senator Hatch said, elections matter. The 2014 election matters. I would submit, just one last point, Merrick Garland is reflective of the balance of power. His age, he's even older than I am, is itself a compromise. Right. And if you read his opinions, this is not someone who should be anathema to either party.
On that optimistic note, that we will all come together and find consensus for judicial nominees in the future. As a reporter, I will thoroughly enjoy finding a way to see people trying to pursue that, but also getting great headlines when it's not the case. I really appreciate everybody showing up this morning, and thank you. And I apologize, but I have to run over to the Supreme Court for opinions and arguments. So thank you so much.
Is that it?